Again, like I mentioned earlier, fraternization policies will also be an issue. So if you have employees in the workplace who are having an improper sexual relationship or just a sexual relationship together, you will not be able to regulate that under this ordinance because that will be a form of sexual orientation. And if you do try to regulate it, you'll have to go through litigation to find out whether or not you're right, because it's not clear on the face of the ordinance. And that is not, by the way, and let me back up real quick, that is not to slight the work of the city or the city attorney's office or Larry in working on this, because frankly, this is a very, very difficult task. Normally, the creation of these kind of boards and the creation of these kind of laws is a months, if not years-long task done by, an ant colony of lawyers. So this is a significantly difficult thing, and frankly, the ordinance which you have before you today is a significant improvement on the ordinance that was before the City Council not too long ago. So this is not to cast aspersions on anyone's hard work. It's just these are very difficult areas to regulate in because of their nature. So those are the general problems, just with any type of ordinance that regulates in this area. I'd like to take a few minutes and walk through some of the specifics that on the language of this ordinance will be a problem if it's not changed. If we could go to page 3. It's very important for the language in the ordinance to be really ultra clear about what it's trying to do, because one of the key constructions of the ordinance, if you go to page 6, you'll see at the top of the page, section 10-3A. Every provision is supposed to be construed liberally as for the maximum impact. So if it seems a little strange to think that we'd have to take down the men and women signs out there, you have to remember it's not just a little strange that it has to be outside the plain meaning of the language. It needs to be a lot strange. It needs to actually contradict the language to do something for this requirement here, that any of the language you're looking at before you is supposed to be read very, very broadly. So if we go back to page 3, it's very unusual, and I'm going to address things both in the context of religious liberty, the broader litigation concerns, and just some law issues for your consideration. It's very unusual for a city ordinance to purport to bind not just the city employees and not just the people within its jurisdiction, but also the superior government entities over it, especially, for instance, the federal government. Given that you have Fort Riley not too far away from you, that is a significant consideration, and county employees who might be working within the area. If you look at the state ordinance, or the state law rather, under, let's see, I don't have the section in front of me, but I can get it for you later if that'd be helpful. It does not attempt to do that. It only binds all governments that are under the state and below. It does not attempt to bind any governments that are above the state. So it specifically does not include the federal government in its definition of employer. Just something for your consideration. If you please go to page 4, under the definition of public accommodation. This is a very important section. Right now, and this has been rewritten to be improved over where it was before, but unfortunately, because of the language that is where it is right now, this doesn't exempt a single church, a single ministry, a single social religious group. It doesn't exempt homeless shelters. It doesn't exempt Boy Scouts. It doesn't exempt anybody. Because what it says here, or at least not most of these organizations, because it says, one, you have to be owned and operated, whatever this particular public accommodation is, by a religious organization, and these accommodations can only be open to your group that's coming there. So for instance, in the situation of a church, how many churches only allow people that are already, say, Christians or Baptists to come to their church? It's not the purpose of most churches, not the purpose of most social groups. They're intentionally broad. They intentionally welcome the public and aren't exclusive to their leadership and to their membership. And so right now the definition says if you invite anybody else in, Christian camp, Christian daycare, Christian church, anything of this nature, the Boy Scouts, you don't get this exemption. It's a significant problem. It's a religious liberty problem. That's a First Amendment problem that if it was upheld here and everywhere else, it would go to the U.S. Supreme Court and be struck down because the Supreme Court's already addressed this kind of issue. Now, it can be fixed fairly easily by using the language which is in the state statute under public accommodations, which says that, just frankly, it's section 44-1002, section H. And it simply says public accommodations do not include a religious or nonprofit, fraternal, or a social association or corporation, period. That's all it does. And so it doesn't matter who you're inviting to come in or who you're trying to associate with. And frankly, when we're talking about gender identity and sexual orientation, most of the churches I'm aware of would love to have individuals who are engaged in that kind of behavior attend their meetings. That's not the issue. The issue is whether or not they have to change their identity, change their teaching, and things of that nature. So this ordinance, I would highly recommend, and it really needs to comport with constitutional law, that it be changed to match the state statute in the same provision, the same exact type of provision. Also, if you did that, it would address the other issues that are on here as well. Page 5. The religious organization definition, which was very helpfully clarified by the Assistant City Attorney earlier. I had the same question that Mr. Hampton did, and I think that she answered it admirably. One of the issues that we'll have with this, though, one of the concerns that you'll have with this going forward, is that it doesn't protect rights of conscience. It still protects these religious organizations that are protected under Title VII and protected admirably under Title VII. But if you have someone like the Elaine Photography or something of that nature, she is not going to be protected, even though the Kansas Constitution requires that rights of conscience be protected, that people don't be forced to do things that violates their conscience. That's in the Bill of Rights, subsection number 7. So it'd be important to actually expand beyond just the definition of Title VII, because we're talking about an issue which isn't like race or nationality, a morally neutral issue, but something that a lot of people have a very divergent opinion on, as the broad audience you have here before you today indicates. So it would be necessary to do that. And it's difficult, and because, like we were saying earlier, about the liberal construction which is given to language, if we don't use a broad religious exemption, and I would be glad to provide one to this board if that would be helpful, if you don't use as broad a religious exemption as possible, then you don't have real religious liberty protection in the first place. Because if a church is wondering, or a religious group is wondering, or a small business owner is wondering, what can I do, especially if they're trying to protect the bottom line, especially if they're trying to avoid years of litigation, what they will do is go along with the ordinance, because otherwise they're risking basically ceasing to exist as an entity otherwise. If you don't have broad protections, then you will have losses of liberty, even if nothing is ever enforced against someone, because people are going to start censoring themselves. Does that make sense? If we could go to the definition just slightly down the page there of sexual orientation. And this is what I was addressing earlier. It implicitly includes protection of conduct. You'll see in the last sentence it says sexual orientation does not mean conduct which is prohibited by law. Well, that means it does include conduct which is not prohibited by law. For instance, workplace fraternization. And you won't be able to regulate that kind of thing anymore when you use such a broad definition. You won't be able to keep employees, whether they be a man and a man, or a man and a woman, or a woman and a woman, or whatever other variation of gender there might be, from having a sexual relationship within your workplace, within the city government, because that'll be a violation of this provision that you have before you today, because the broad language is before you. If we look at page 6, you'll see under, right at the top, subsection B. I'm sorry, no, not right at the top, under section 10-6, still subsection B near the bottom. It requires this board in the future be made up as broadly as possible, not just encourages it, but requires it. It says this board shall be made up by a cross-section of the protected classes. There are 14 protected classes before you, and innumerable variations on those classes, different races, different religions, different all sorts of things. There's no way that you'll be able to accomplish that. But even if you did accomplish that, you would be discriminating based on the exact same characteristics that you're ordering the rest of the town, the rest of the city, not to discriminate on. It doesn't set a good example for starting off. And in fact, the state ordinance the state law does not do that. The state law says that under section 44-1003A, while the board members are drawn from a broad cross-section of the community, the discrimination isn't based on a protected class. They're not saying, okay, we have enough Latinos on the board now. Now we need to bring on some other races. We have enough Baptists on the board, now we need to get some more Jews. That's what this language tells you right now. And it requires you to discriminate in a way that no one else is allowed to discriminate and should not discriminate. If we can please go to page 9. The very bottom of the page, under unlawful employment practices, just before the new section gets added, it says you need to have a valid business motive if you're going to discriminate based on these grounds. Valid business motive is, once again, very broad language, and it's going to induce litigation. In fact, the cases that I talked about earlier, the case that was before the 10th Circuit Court of Appeals, was a case where the court said, okay, you do have a valid business motive not to fire an individual with gender identity disorder because this individual is a biological male who was wearing your uniform and was going into the women's restrooms. And that's going to cause you liability, or at least could cause you liability. You're going to get sued because this individual is going into women's restrooms even though he is biologically a male. But you don't know that right now under this valid business motive language. And so a business is going to have to litigate to find out whether or not. Now, you could include an example in here that incorporates case law from around the state and around the country, and that would help. But you're still going to have a tough time with that. Going on to, well, actually, let's address an issue that was brought up earlier regarding intent. The goal of non-discrimination provisions is to stop intentional discrimination. If I just blindly turn around and say, this part of the room, go out, and this part stay, there's a good chance there's more men in one side and more women in the other, something like that. And that would unintentionally be discriminating against whoever I force to leave. Unintentionally. Similarly, if any selection between two classes of people, two individuals, is going to discriminate in some way, and potentially larger on a protected class, and if there's no intent prong, the simple act of doing that, whether you intend to discriminate or not, you have violated the law. So if a employer chooses not, or if the chair chooses to select Mr. Hampton as the next vice chair instead of allowing Ms. Strawn to continue as the vice chair, he will have committed discrimination based on sex. He didn't intend to, and I'm not sure if you can select or not, just an example, but he didn't intend to, but he did because that was discrimination based on sex. By contrast, the state law does include a discrimination, an intent prong. It says, and it's a very simple difference. It's a very simple difference. The language in front of you is fairly close to being good on this point. It just says, if you intend to discriminate because of race, sex, and on and on and on. If you intend to discriminate because of that, then you violated the law. So if the chair intended to discriminate in choosing Mr. Hampton, then he would have violated the law. That's all fine. That's all good. But the way it's written right now, just the simple act by itself would be actionable. And that's consistent with federal law. Title VII does the exact same thing. It includes that because of language. And also that 10th Circuit case that I was telling you about earlier walks through the jurisprudence, the rules on how these cases are done, and says, yeah, it's because of. You have to show there was an intent to discriminate in this way. Okay. Going to page 10. This language that the city attorney's office has put in here is a significant improvement over what was there before. It was very well done. The two recommended changes I would make is, one, it does not say that a religious organization can discriminate based on religion. That's a major problem because most religious organizations discriminate based on religion, say in their leadership. They might say, for instance, we want our pastor to share our beliefs before he starts teaching us. The way this public accommodations law is written right now, they wouldn't be able to do that. You see the distinction? So it's important that in addition to sexual orientation and gender identity, religious organizations are able to discriminate based upon religion to retain their religious identity.